That's every international institution. The point about sovereignty, it is a very definable power, so you can say on what terms are we going to authorize the government to act for us. And there is something about organizations speaking for humanity in their various guises, which all of us should find creepy. It's a quaint phrase to speak of it as the Harvard's prerogative, but thank you.
So I heard that we were starting with the PowerPoint, so not to be outdone, I thought I'd end us with the PowerPoint. I thought, in this crowd, what would be a provocative title? The Case for International Law. And so I'm going to start by talking a little bit about why we have all this international law that's been so criticized here today. Let's see if this clicker actually is working. I don't think so. There we go. All right. So, oops, went too ahead. Sorry. All right. So first of all, it's just worth keeping in mind the context that we're operating within. This is growth in exports and imports since the 1920s. So this is just to say we're living in a more globalized world. There's an increased flow of money and goods and services and people across state borders. That's just a simple fact of life that I don't think we can disagree with. And I think that sets the stage for thinking about what role international law might play and why we have it. I also want to have us as a starting point recognize that most Americans think that it's a good idea to take into account the global response to global problems, right? So if you look at, oh, sorry, this clicker is a little bit out of control here, or at least my use of it is. All right, here we go. So if we look at it's a question asked, which statement comes closer to your position as the sole remaining superpower? The U.S. should continue to be a preeminent world leader in solving international problems. Relatively few Americans say, yes, that's the right response. The vast majority say, no, the U.S. should share its efforts to solve international problems together with other countries. And how do they do that? They do that through international law and through these international institutions. And in fact, the U.S. has been making more and more international agreements. What is this line? This is the number of international agreements the U.S. has entered, beginning from the 1930s to today. Unfortunately, I wasn't able to update this, but the most recent, if you take from 2000 on, it actually jumps up substantially under President Bush. So we're back up to levels that we were at the height of this graph. So we're entering more and more international agreements every year, and it's much more of a fact of the kind of law that we're making. And this is true if you sit down and examine this of Republican presidents, Democratic presidents, Republican Congresses, and Democratic Congresses. This is just a response to the actual needs that we have in the world to deal with global problems through global cooperation. So my basic argument here is that international law does not represent the diminution of sovereignty, but the exercise of it is a tool that can be used to secure U.S. interests. And there are a lot of folks who agree with me. Oh, shoot, this got turned around. All right, so one person who agrees with me, former President Bush, the first. This is just one example, pulling from his discussion about the START Treaty. Says the START Treaty is in the interest of the United States, represents an important step in the stabilization of strategic nuclear balance. John Bellinger, the legal advisor for George Bush II, who immediately preceded the current legal advisor and was the legal advisor during the entire second term of George Bush. He was testifying before the Senate in favor of arms control treaties, said ratification would promote U.S. international security interests and vigorously supporting, along with our friends and allies, both the rule of law and appropriate development of international humanitarian law. Additionally, when the United States ratifies the treaty, other nations are more likely to ratify as well, with the result that overall implementation of and compliance with those norms will improve over time, which ultimately helps to protect our forces. So he's making an argument of self-interest. International law, why do we join it? Not because we have this vision of being told what to do by some amorphous international body, but because it serves our strategic national interests. Anybody know what this is?
flag on the Arctic Circle?
All right, the Russian flag on the bottom of the Arctic Sea. So Russia plants this flag as an effort to try and lay claim to a portion of the Arctic Sea, which, as you all know, is now melting and opening up not only sea routes, but also access to all kinds of underground oil and natural gas resources that those surrounding the Arctic are all interested in laying claim to. We, of course, have a claim to a portion of this ourselves. And Russia, in a sort of bold move meant to kind of echo our efforts to plant the flag on the moon, went and planted the flag on the bottom of contested area of this ocean. And the question is, what can we do about it? Well, international law helps us answer that question. So here's James Baker and George Shultz in the Wall Street Journal. The U.S. finally becomes party to this treaty, speaking of the Law of the Sea Treaty, which I know is, I chose this because I know it's a particularly unpopular treaty in this crowd. It will be a boon for our national security and our economic interests. U.S. accession will codify our maritime rights and give us new tools to advance national interests. And he goes on to explain that, in fact, this has been, that Russians are attempting to lay claim to this area, and our best response is to be a part of this international body that allows us to have a seat at the table, to actually defend our rights in a collective forum. And they're not alone. There was a letter that was written by a set of military officers and political leaders making precisely the same case. I know we have some members of the military, of the Navy here in particular, who are saying the convention codifies and strengthens freedoms of navigation and overflight that are essential to U.S. military mobility. The Navy and Coast Guard have testified that joining the convention will strengthen our ability to defend these and other important maritime rights and will enhance our national and homeland security efforts. So again, the argument here is not there's some amorphous kind of general reason that we should join this that is about sort of subsuming pulling our sovereignty, subsuming our own self-interest to the greater good. It's about defending U.S. national self-interest by being part of an organization that allows us to articulate our own interests and secure them most effectively. I'll say that none of this, and I haven't mentioned here, and I'm happy to answer questions about, none of this, of course, gets to those questions that were raised about customary international law, for instance. Though I will note the U.S. has formally declared that we recognize the Law of the Sea Convention as customary international law and have acted in accordance with the Law of the Sea Convention as customary international law, but is announced by us to be recognized as customary law, which we intend to follow as a result. And that was an intentional choice made to take advantage of some of the benefits of the convention while not necessarily having to abide by some of the specific provisions of the earliest version of the convention, which has now been revised. But aside from this, I can't think of certainly, actually, in addition to this, I can't think of a single example, and I'd be interested if you can, of where the United States has been forced to do something because of customary international law that it otherwise would not have chosen to do. Maybe you can come up with an example. I can't, and I teach international law. Customary international law operates at a much softer level. It is about having disagreements, discussions among sovereign nations, but there is, of course, a persistent objector rule. So if the United States persistently objects to the formation of a customary norm, it's understood that it doesn't apply to the United States and cannot be even seen to be legally binding on the United States. This is built into the entire idea of customary international law, the fundamental element of customary international law. So even when we're talking about customary international law, there is a strong principle of sovereign consent built in to international law, even in this area that might be considered the least consensual element of international law. The only area in which you're going to see peremptory, what are referred to as peremptory norms, is a very, very, very small subset. For instance, the peremptory norm against genocide. Again, I can't imagine the United States wants to declare